Hi, everybody. How are you? We are together with Latoya again to talk about the latest immigration news and updates. It's been almost 6 weeks since we did the last one. And while preparing for this conversation, we went through the stuff and we were like, we're not going to be able to cover everything again, but let's at least go over some important updates. Latoya, welcome to the channel again. How are you?
Hey, Remzi, I'm doing terrific. How are you?
I'm okay, hanging in there. I mean,
Yeah,
we cannot.
so are we. Things with immigration, we started off this year talking about all these big problems, and then we had another podcast talking about new big problems. And now, my God, it doesn't end, right? There's a lot to cover, some good, some bad, but it's just like it's never ending this year.
It's never ending, exactly. And it looks like it is going to be like this for a while. Why don't we immediately start with one of the latest developments, which is Department of Homeland Security's latest announcement that the employment authorization documents, the EADs, the work permits, will not be extended automatically anymore.
Right. Yeah.
Maybe a little background on it first is, because it was taking a long time to extend these EADs, they were taking about 12 months to look at these applications. USCIS said, well, why don't we give you the extension as long as
Hmm.
you file your EAD extension application before your current EAD expires, you will have 540 days to work until we adjudicate your application. That is how bad things were. And people were good with it and okay with it because at least they didn't lose their jobs. And now USCIS is taking it back. Is it because USCIS would like to take a look at these applications, adjudicate applications within the 180-day period, or is there a different reason for it? What do you think?
I think certainly there's another reason for it. I mean, the government has said they'd like to do more vetting of applicants. And in this day and age, with technology being as advanced as it is, and the capability that the government has to investigate applicants, I think it's fairly easy and fast for them to review a simple I-765 employment authorization document and make a very quick decision about the applicant. I think that it's just another reason that the government is using to slow things down, to frustrate the process, to discourage people, to squeeze them, so to speak. And that's putting it lightly, to squeeze them into this corner that would cause them to just give up. And also, I think USCIS, as you've been seeing, and I'm certain our audience has seen this as well, USCIS has really changed its tone, its language, and even its mission. And they're so very much now on the law enforcement side of things and protecting the homeland with ICE that apparently they don't want to have any policies in place that makes it appear that they're softer than that image of the protector of the homeland and going after dangerous people. It's just unfortunate that regular folks who are doing everything right they're caught up in this. I just think that it's just unnecessary and it's cruel.
It is. And I mean, a word of advice would be probably if you don't extend your EADs on time, if you don't get them approved, you may lose your job. I think
Yeah.
that's very important. And what do you think would be good advice for people who have EADs, which is ending soon, let's say in the next year or so?
Mhm.
What would be the best steps to take now so that you have an EAD, current EAD, valid EAD before your EAD ends?
Well, certainly filing early for the renewal. The government recommends 180 days. And before we came on today, you and I were talking about potentially having our own clients apply earlier than that, because I think there's going to be a math problem for some people. Because certainly, if it takes the government 12 months or longer to approve the renewal of an EAD, and applicant does everything right, they file early, well, they're still going to experience a gap and go for a period of time without their EAD. And for some people, they could actually lose their job, and they will lose their job as a result of not having a valid EAD on file. So certainly start in now, start in early, get that renewal in. You mentioned to me before we started recording, that you'd even take the risk of filing even sooner than 180 days.
Yes, because 180 days is recommended by USCIS, but there were instances where you could file the EADs earlier, let's say 8 months, 9 months earlier, and those cases were approved. I didn't see any denials. There's nothing that says official that you can do that, and I don't think they want to say that because they don't want to overcrowd the system.
Right.
But at the same time, it is a fact that these cases will take longer and longer and longer to process, which, by the way, was the case in the first place, why EAD extension authorization came into this world. So I don't know, it's a step back. It's not with good intent. I don't think so. You were mentioning Mandamus before we talked about, so I was just gonna, before I forget, yes.
Yeah, absolutely. So we're going to be very aggressive, right? We're going to push back as much as possible so that our clients won't lose their job. So for instance, if you filed early and there's still a delay with the processing of the EAD, well, before your EAD actually expires, I would say maybe 2 to 3 months before it expires, consider working with a lawyer on filing the mandamus to force the government to take that next fast move in your case, which hopefully will be the approval of the EAD so that you could keep your job. That's really the advice that I'm given today. Be very aggressive with the government because it's unreasonable what they're doing to people.
Absolutely. I think there's an uptick in mandamus cases because it's one of the ways where you can have federal government do what they're supposed to do. If they're doing what they're supposed to do, there's no litigation. But if they're not doing what they're supposed to do, thanks God in this country there's a lawsuit called Mandamus lawsuit, and you're gonna have a judge tell the federal government to do what they're supposed to do. Some people think that, especially some people in the immigrant community think that, well, are you kidding me? If you're suing the government, how are they gonna be acting good on your case? They're not gonna approve your case. People need to understand these are two separate things.
Yeah.
It's the judge who's telling the federal government what to do, and they cannot hold a mandamus case against you. So that's not going to affect your case. It's a very important distinction. Most people don't want to sue the government, but sometimes it's the only way.
Right, it is the only way. And sometimes they think that that adjudicating officer who's going to be looking at their file will be upset somehow they've filed this mandamus, and that's not how it works.
It doesn't work like that. What I've experienced in our mandamus cases is that the immigration officers are even more careful because there's a mandamus and there's usually a settlement before the mandamus action moved forward. There's usually the government's attorney and the mandamus attorney settled something. If it's an interview, give the interview on such and such date and decide on the case within the next 60 days. If they don't do that, they're afraid that they're going to violate the settlement terms, and it's even worse for them. So I love mandamus. I'm sure you do too. Sometimes
of course.
It's the only way. Do you want to talk a little bit about the family-based, what's going on in the family-based immigration, federal litigation? That area is very active right now.
It is. What we're seeing more so than anything else, of course, are people coming to us who are afraid. First of all, afraid to file because of what they're seeing on TikTok, YouTube, Facebook, of course, of people being arrested at the courthouses or even at USCIS's office. So we're often asked, should I file now? Should I wait? What will be my chance of success if I go for it right now? And so that's almost a daily discussion that we're having with folks. But really at USCIS now, they're very aggressive with some family cases. So for instance, if a person files an I-130 petition, yet they have a final order of removal, what we're seeing now in some parts of the country is USCIS is actually working with ICE to have that individual arrested. And once that person is arrested, this is not a widespread problem quite yet, but it is picking up steam. Once that person is arrested, then everything changes, right? You're talking potentially federal litigation with an action like a writ of habeas corpus to challenge their detention, and a TRO, temporary restraining order, to stop the government from going further with that person in terms of moving that person maybe to a different state and deporting that person. So us immigration lawyers are really handling more federal litigation of people who unfortunately are caught up in this process of cutting off their due process rights and facing imminent deportation as a result of how aggressive the government has become. So when clients come to us in those scenarios, we have to be flexible. We have to look at all possible strategies to try to keep them here in the US. We have to consider making those strong arguments that their due process or constitutional rights have been cut off. So we're involved in a lot of that these days.
Many people are concerned about being arrested when they go to their USCIS marriage interviews or naturalization interviews. And I'm telling most people, most of the time, you don't get arrested there. You usually get arrested at the court during a hearing, before the hearing, or after the hearing. What is your experience with that?
A whole lot of people are not being arrested, right? I tell clients that a whole lot of people are going to court each day. A whole lot of people are going to USCIS field offices each day, and they're not all being arrested. The government is, for the most part, looking for a core set of facts to go after certain individuals with those facts. So, for example, what we've seen, what we've experienced is this. With USCIS, they're looking for fraud on the record. Typically, that fraud is the result of a past filing in a marriage case, for example, and the government concluded that it looks like that person committed marriage fraud, for instance. Well, they're looking for individuals like that, right? So those people, I would say, are more at risk of being detained at a USCIS field office than person who goes in without an immigration negative record. They're certainly also still looking for people with a criminal record. By the way, we discussed back in the spring that a lot of people were concerned about whether they could travel or not. And I think that to some extent that fear has died down a little bit. But there is still a concern about traveling if you have a criminal record. And for me, Remzi, I don't know what you've been telling people, but I've just been saying to green card holders and others, do not travel if you have a criminal record, not at this time. Just don't take the risk. But anyway, courthouse arrests are happening more so in Manhattan than any other immigration court across the country. Again, thousands of people go before immigration judges each day, and most of them are not arrested.
Agreed. Exactly. And there's also the quota that
Oh,
I set.
yeah.
So it's 3,000 people per day in the US. So it's easier to go to the courthouses and some restaurants, find these people who they are looking for. That is the reason why you see this. But as long as the quota is there, I don't think they bother too much. And also, you cannot give statistics, but if you were to say 98% and 99% of people who go to the court and immigration every day don't get arrested, maybe only a few.
Yeah, most people don't.
So one latest announcement from the CBP was to require biometric data for non-citizens entering and exiting the US. And this had some interesting things in it, asking for petitioners to give biometrics, for example, which was never the case up until now. Now, this is still in the rulemaking process. I think the comments are due in a month or so. But what do you think about this announcement?
Oh, I hate it. I hate it. I think that, well, first of all, my understanding of things is that the government recently proposed a rule to collect more data from people who are involved in the immigration process. And this data collection extends to petitioners, sponsors, beneficiaries, derivatives. In fact, everyone who's involved in the filing, except attorneys and accredited representatives, are now, well, if this goes through and becomes a final rule, would be required to provide biometrics data and regard to age. And also, it includes DNA collection, an expansion of DNA collection. And so the big question, I think, Remzi, is why, why, right? Why does the government need so much data? Why are they looking to collect data from petitioners and sponsors and others? Why is this even necessary, right? I think it's an overreach, it's outrageous. And you mentioned that there is a public commenting period. It ends January 2nd. So we've got to leave those comments to share with the government what we really think about this, because I just find that this is an expansion of privacy, expansion of powers, I should say.
I think it's a way to tell people not to petition, because most people are not going to be bothered with giving biometrics, getting under some sort of government control, so to speak, right? People don't like that. I mean, it's
not at all.
I think a way of saying don't sponsor people, and people who are trying to come here don't come here. Basically, people who are here leave, people who are not here don't come. I think I don't see any good intent in this. I mean, how can you serve community, the public interest, by requiring more biometrics from petitioners? These people are already in the US. You already know everything about them. You have their information, etc. Why do you need to get biometrics from these petitioners? I understand it from beneficiaries, but why the petitioners?
The government already has fraud detection system in place to collect DNA from parents who are claiming that this is their child, right? To prove the child-parent relationship. Certainly, the government ask for DNA collection. And we see that a lot with consular cases of our US citizen petitioning parent, petitioning for an adult son or daughter overseas, while the government wants to be certain that that is in fact the son or daughter. And so they typically request DNA, and that's okay, that's in place. But why expand it in this manner and so early into the process of filing? It just doesn't make sense to me. So this, to me, I think is huge.
It is. And let's see what the final rule is going to be, but it's in the comment making process. Now, maybe that's a nice segue to the developments on the U visa, because now the government is considering not allowing U visa holders to file for adjustment of status if they enter the country without inspection.
That's another mind-boggling thing, right? Because as a victim of a crime, our government promised that if you cooperate with law enforcement, if you give us information to help us prosecute a case, to find the bad guy, to keep our communities safer, well, in turn, we'll give you lawful status. It's going to be temporary in the beginning. And after a certain period of time, 3 years, I believe, you'll then be able to adjust your status and have permanent residency. And then who knows, maybe one day you could become a US citizen. Well, now the government is reneging on that promise for some people and saying that if they enter the United States without inspection, that they will not be able to adjust their status. They could actually only go so far in this process.
Yes, exactly. Some people are just sitting down all day long and trying to find these little, they can just find.
I think they're looking for anything that appears good and helpful to immigrants and just saying, oh, let's go after that one. Let's get rid of this other thing. I think that's really the extent of it.
I always tell people that, don't look at the bad things. There's also good things, and we're going to talk about this in a little. But at the same time, day after day after day after you start seeing this, and you're like, is this ever going to end? We don't know. The only thing we can do is continue fighting, I guess, right? That's what I tell my clients. I mean, the fundamentals of the immigration law has not changed. I mean, you can still file, you can still get cases approved. Yes, the evaluation is a little different, the rhetoric is different, the discretion is different, but we still get cases approved. We never give up. I mean,
no, we have to fight the good fight. Keep fighting it.
Immigrants and immigrant advocates, we never give up. Another announcement from USCIS, which was very confusing, was the $100,000 H-1B fee requirement. When they came up with it on a Friday night, my whole weekend was ruined, because we were trying to understand what they meant by it. And because government says it, you think that it is right? Then turns out it was not right. They came out with an explanation on Sunday night. And then since then, they had to explain themselves 2 more times. I think they still need at least 3 or 4 different announcements to really clearly understand what it means. But this is where we stand right now. It looks like if it's a new H-1B, you're subject to the $100,000 fee. But if it's a change of status in the US, if it's an extension of status in the US, or it's an amendment in the US, then you are not subject. So let's say you had an H-1B before, you're filing for an extension of status within the US and it gets approved, you're not subject. Let's say you are on an F1, you have an OPT, and you're filing for a change of status, and your H-1B gets approved, you are not subject. Even if later you leave the US and you apply for an H-1B visa at the consulate, you are not subject because it was filed as an extension or as a change of status within the US. On the other hand, if you were an H-1B holder before and you filed for an H-1B extension and it got denied for some reason, for example, you were not maintaining your status, and you have to go now to the consulate to get the H-1B visa, it looks like you're going to be subject to the $100,000 fee, which doesn't make quite sense, right? Because the idea behind this was to prevent from the new H-1B holders to come to the US without the payment of the $100,000 fees. I don't know how those two stand together. If what is very clear is if you are subject to the H-1B quota, you're getting it at the US consulate, then you're subject. First time H-1B at the US consulate, you're subject to the $100,000 fee. So these are the clear things. What is interesting is nonprofit educational institutions, higher education institutions, research organizations are not exempted from this fee. So that's seems to be a huge problem because professors, researchers either losing their jobs or they don't know what's going to happen to them in the upcoming H-1B renewal period, because let's face it, most of them are not even making $100,000. I mean, this is even higher than their salary.
Yeah.
And these are vulnerable communities, or these are organizations which don't make a lot of money anyway. These are called nonprofits. So to have them pay $100,000 fee and not exempt them from this requirement simply to me doesn't make sense. So maybe there will be a new explanation, clarification about it. But this is where we stand right now.
Yeah, and this we have to also remember that who else benefits from H-1B? Qualified workers. Well, state government agencies, local government agencies also use experienced foreign workers to fill the gap and needs that they have as well. We've already mentioned school systems and research institutions and such, but so does the government. And so it's just mind-blowing to think that our government would actually remove such an opportunity for businesses and government to have qualified workers. Have you had any clients, though, Remzi, that was subject to this fee?
Not yet, because
No cap exempt clients.
I do have exempt clients, but they prefer now hiring employees who are already in the US, meaning they're on an F1, OPT, STEM OPT, because if they know if they get this person and file a change of status, then there will be no fee. So instead of bringing them up from overseas, they want to hire from here.
Right.
I only have come across one client who said, well, $100,000 is great because I really want to bring this guy, and I don't think I was going to be able to get into the quota. So I think if you are really going after a huge employee who's going to make a lot of difference in your organization, maybe it is worth it. But I mean, let's face it, Trump did it because of the Indian IT companies. Everybody knows it. 75% of the H-1B visas are being used by these IT companies. But what about the other 35%, right? What about the researchers? What about the market research analysts, financial analysts? What about the really qualified executives and IT personnel? What about the people who went to school in the US with the hope that they can work in the US? I think there's still no common middle ground. I think it is still very unrealistic and it doesn't make sense at a lot of certain points.
I know we hadn't talked about this one though, but I'm curious to get your thought about the gold visa, right? The Trump card, so to speak. Anyone on your side of things interested or approached you and said, hey, how do I get
Yeah,
me a Trump gold card? I hear that it's opening up in December. Is this
yeah,
something that, your firm is going to
yeah.
help folks with?
We're gonna have people with it if it ever opens up, right? But yeah, some people showed interest. Once they realize that there is nothing to do at this point, they're like, okay, let's wait. But it is important to understand that if this opens up, it will be a gift. It will be a donation. You're not getting the money back. And
Mhm.
also, if you have to wait because of your nationality in one of the EB1 or EB2 categories, let's say you're Indian, you're Chinese, you're Mexican, and you have to wait for visa availability in one of these categories, getting and applying for this is not going to help you. You still have to wait. I mean, you're going to get a case approved maybe on the I-140 side or whatever form they come up with. But you still have to wait to file a 485 or go and get your visa at the US consulate, because instead of coming up with a new category, they somehow sneaked it in behind the doors on the EB1 and EB2 category. And now people who are investing this money is all of a sudden extraordinary ability people or national interest favor people. So there's a lot of problems with this logic.
Yeah, and my understanding is that it's somehow built in some sort of expedited process and as well. We haven't seen the regulations about how any of this is even going to work. And furthermore, it's going to be run by the Department of Labor, handling immigration cases.
Department of Commerce,
Department of Commerce, I meant. I'm sorry, Department of Commerce.
Department of Commerce and USCIS. I don't know what kind of a combination that is. I think Department of Commerce just comes in to collect the money and doesn't do anything as far as the adjudication is concerned. Expedited means expediting the immigrant visa petition, not the green card itself, because you have to wait for visa availability. You're going to be subject to the regular checks. So yeah, we'll see. We'll see how it goes. There's still not a lot of details about it.
So the government shutdown. Let's talk about that for a minute, because as of the filming of today's video, the government is still shut down. But immigration is still moving, though. Immigration courts are still having hearings, holding their hearings. USCIS is still working. Although USCIS is starting to slow down in some ways, they're still processing cases and calling folks in for interviews and approving cases and such. But what's going on over at the Department of Labor? What are you seeing on that side, Remzi?
Because Department of Labor is not working on a fee-based system, when a government shutdown occurs, it's the Department of Labor who gets affected the most. This is true for PERM cases where you cannot file a prevailing wage determination or file a Form 9089, which is the PERM application. It is true for H1Bs and H2Bs where you cannot file an LCA, labor condition application. So it affects those cases a lot. And you know what happened? In the last 30 days that the government was shut down, we missed deadlines. Because you cannot file an LCA, because you cannot file a PERM application, certain time periods were run out and we missed deadlines. So now we are trying to understand what are we going to do with those cases.
And the government didn't extend any additional grace period on any of that? No.
No, they are. We think that they're going to come up with an explanation as to how these cases can be late filed, right? And it's not easy to late file them because PERM, for example, is all online. So the system doesn't allow you to go through the application. It's going to get automatically denied if you file it now because the period has passed. So they're going to come up with some kind of an explanation or announcement, guidance as to how we can do these things. We filed some of them paper, but because they don't want paper filing, it's a very difficult process. They made it difficult knowingly.
Yeah.
And so we will see how that goes. But very interestingly, and I think this is happening for the first time, although the government is still shut down, the Department of Labor opened up its flag system now where you can process LCAs for H1Bs and H2Bs and Form 9089 and 9141 for PERM applications. Latoya, I think I'm seeing it for the first time in my years of practice, where I saw government shutdowns, but the Department of Labor was never open before the government opened. But this time they did, because they realized this is coming to a point where they cannot handle. There is no way to undo things once it's done. So they decided to open the Department of Labor, which is, at least good for us, because it was only closed for 35 days. There was some damage done, and hopefully we can fix it. But at least on the immigration side, it seems like we're going to be in better shape in the upcoming days.
Okay, we'll see.
It also affected the DV lottery.
Oh, that's right. The DV lottery, which as of the filming of this video, we still haven't even gotten an announcement from the government about the lottery, and a lot of anxious people around the world are waiting to be able to participate in this.
Actually, my paralegal just handed out a note to me.
Oh.
This is an update from the Department of State. They're saying the department is implementing certain changes to the diversity visa entry process. We will announce the start date for the DV 2027 registration period as soon as practicable, as well as the date the DV 27 election results may become available through the entry status check. These changes will not affect the visa application period for individuals selected for DV 2027, which will remain October 1st, 2026 to September 3rd, 2027. So what they're saying is the selection period will be a little bit late, but the application period will be the same. So at least finally, 35 days after they were supposed to open this selection process, there's an announcement that they're working on the progress. So that's a relief. I know, it's crazy. We are seeing things, Latoya, that we have never seen before.
We're staying afloat. We're not, I don't like to think about us treading water, right? We're trying to stay on top of things and shift and respond accordingly for our clients.
Exactly. And also, there are good things that are happening. Tell me some of the good things that are happening.
USCIS is, to their credit, they're still actually functioning. They're still actually reviewing cases. Some cases are moving fast still. Some marriage cases are being processed. We've been testifying as of late about some of our marriage cases being approved in 3 months. Even folks who were interviewed by the government. People are still winning their cases in immigration court. Good things are still happening despite what we're seeing. It's just that now with immigration, you have to really go in with both eyes open, right? You have to know what type of case you have, whether you're truly qualified. You can't just sign something and submit it to the government and not even know what it is that you've submitted. You have to really be intentional about your case and stay on top of it. And it could work out. It could really work out for you. And we're seeing the results.
Same experience here. I've gotten, last week, I think, I was marriage interview in 26 Federal Plaza. It had been only 2 months since we filed the case. There was even nothing to update on the documents. And everything was uploaded in the online system. And we got out of the interview, and the interview was approved a few hours later. So to their credit, they are really working fast, and they are actually doing their job. And to tell you the truth, I haven't seen a lot of slowdown on processing of other cases either. So yes, there's more security checks. Yes, there's more biometrics. They are talking about all of these things, but when you look at it, when you file something with USCIS, there doesn't seem to be a lot of lateness or slowing down in the last year or so. This is true for marriage cases, for naturalization applications. And some of the things that are taking longer were already taking longer in the prior administration too. So credit is when credit due, I guess.
Right, exactly. And before we go, we know that birthright citizenship is still pending at the U.S. Supreme Court level. And on the merits this time, the substance of it is before the court. And so you know, they've had oral arguments. Have they had oral arguments on this? I don't think so. Have they?
I haven't seen anything.
Uh, yeah, I don't think they had. They've agreed to take it. The Supreme Court has agreed to take up the issue of birthright citizenship and whether children born of undocumented immigrants and those who are here temporarily on a visa, whether those children are in fact U.S. citizens. So hopefully, at some point, we'll hear those oral arguments, and we're hoping that the court will do the right thing with respect to birthright citizenship. So I'm staying hopeful in that regard.
Yeah, I am too. I mean, let's hope for the best. I mean, nothing. This is not political, but I am glad New York City is now being. The mayor of New York City is now an immigrant.
That is political. That's quite political.
Let's not say that. Yes, let's certainly hope for the best. We are fighters at the end. I always say this. I like fighting for my clients. I started doing commercial litigation 25 years ago. I didn't like it. I didn't like fighting with the people. It was not in my nature. But when I started doing immigration law and just preparing files, submitting it to the government, trying to convince them that this is a good case, somehow I liked it, and I still like doing it. And I think there is great value in this. Bringing immigrants to the US who really make a difference. So let's continue doing that. And I am sure we will have something like this in the near future, because whenever we think that it's too soon, we realize that there's a lot of developments, and even we cannot even go through all of them. So hopefully we will do something like this in the near future, Latoya.
Absolutely, Remzi. This was terrific. For our audience, we talked about a lot of different things. There's the half has yet to really be told, right? It's ever changing. There are so many new policies here and there, but we try our best to come to you with what we think to be the most pertinent information that we could think of it in the moment. And so, Remzi, this was wonderful. Thank you again for having me. I'm your guest this time.
Always.
This was terrific, and let's continue to fight that good fight for our clients.
Let's do that. See you later.
Thank you. Bye-bye.
Bye.